The investigator's next words would change 4 lives and shut down a medical office's entire payroll system forever. "We've reviewed your records. This wasn't a clerical error. This was willful." When a front desk worker in Pennsylvania noticed her 35 minutes of overtime had quietly vanished from her time card, she did something simple. She took a screenshot. What came next exposed a pattern of wage theft that nobody in that building saw coming. Here's the full story. To understand how we got here, you need to understand where this story begins. A small medical office somewhere in Pennsylvania. For the purposes of this case, we'll call our central figure Sarah. Sarah worked the front desk, scheduling, insurance coordination, patient intake, the unglamorous operational backbone of any medical practice. She was good at it. She cared about doing it well. And for about a year, that dedication was being quietly exploited. Every evening, the texts would come in. Sometimes it was simple, "Who's confirmed for tomorrow?" Sometimes it spiraled into 15 back-and-forth messages about schedule changes, insurance disputes, or patients who needed a callback first thing in the morning. Sarah answered them, not because she was required to, because the alternative, walking into chaos the next day, felt worse than a few minutes on her phone. That was the trap, and she didn't see it yet. Here's the legal wrinkle nobody at that office ever considered. Sarah never tracked that time. She never clocked in for those evening sessions. It was framed as part of the culture, a few minutes here and there to keep things running. But burnout doesn't negotiate. Eventually, Sarah stopped responding after hours. And the moment she did, her manager's attitude shifted in a way that should have been a warning sign. Shortly after, the timecard edits appeared. When Sarah reviewed her online timecard, she found 2 edits that made no sense. On one day, she had stayed 35 minutes late helping a patient through a complicated insurance issue. That overtime had been erased, her end time quietly rolled back to her scheduled shift. On another day, her 22-minute lunch break had been changed in the system to a full 60 minutes. 38 extra minutes, just subtracted from her pay. She took screenshots immediately. Now I have to ask, what would you do in that moment? From Sarah's perspective, this was not a clerical error. She had lived through both of those days. She knew exactly when she left the building and exactly how long her lunch lasted. When she confronted her manager directly, the response wasn't an explanation. It was an accusation. "Stop nickel and diming the office." And then came the line that made her stomach drop. "If you want to be strict about boundaries, we can be strict about everything, including rounding issues and breaks." That sentence would later appear in a federal investigative report. Now, and this is where Courtroom Chronicles always insists on honesty, we have to look at the other side. The manager had her own internal logic. She believed she had absorbed unpaid costs too, time spent cleaning up workflow problems, covering gaps, carrying a chronically understaffed practice. In her mind, this was an informal economy of mutual sacrifice. Sarah stopped participating. The manager adjusted what she could control. That logic, however sincerely she held it, is not a defense under American wage law. This is the pattern that creates wage theft cases across the country. Not cartoon villainy, just a workplace where legal obligations quietly get replaced by unwritten arrangements. I give a little, you give a little. The problem is that federal wage law has zero tolerance for informal arrangements. Every hour worked must be paid. Every timecard edit must be accurate. And good intentions, however genuine, are legally irrelevant. And then there's the matter of those after-hours texts. For a full year, Sarah had been reviewing schedules, fielding insurance questions, and coordinating the next morning's workflow from her personal phone, at home, off the clock. Under the Fair Labor Standards Act, the FLSA, if an employer knows or has reason to know an employee is performing work, that time must be compensated. The medium doesn't matter. The location doesn't matter. Work is work. Sarah had been donating hours to her employer for 12 months. Let's talk law for a moment, because this is where things get genuinely fascinating. Pennsylvania workers are protected under 2 major frameworks. First, the Federal Fair Labor Standards Act, or FLSA, which governs minimum wage, overtime, and requires that all hours worked be compensated. Second, Pennsylvania's wage payment and collection law, which adds state-level protections around timely and accurate payment. Sarah had potential claims under both, and investigators were about to apply them to every employee in that office. Under the FLSA, employers are flatly prohibited from editing time records in ways that reduce employee pay. Even where rounding policies are technically permitted, they must be neutral. They cannot systematically benefit the employer at the worker's expense. Rolling back 35 minutes of verified overtime, violation. Inflating a lunch break from 22 minutes to 60, violation. There is no gray area here. And here's the counterintuitive part. Intent doesn't change the analysis. And here is the legal development that changed this case's entire trajectory. Retaliation protections. When the manager responded to Sarah's wage inquiry with veiled threats, "We can be strict about everything, including rounding issues," that conversation potentially crossed into illegal retaliation under federal law. Sarah didn't know that when it happened, but she did something right. She started photographing her clock-ins and logging every after-hours message. She was building a legal record without realizing it. Sarah filed a formal complaint with the Pennsylvania Department of Labor and Industries Bureau of Labor Law Compliance. She also filed a parallel complaint with the U.S. Department of Labor's Wage and Hour Division, which holds jurisdiction over FLSA violations. Filing with both agencies simultaneously is standard strategy in cases like this. It creates redundancy and applies pressure from two directions at once. And critically, Sarah paid nothing. The government investigated on her behalf. What neither Sarah nor the medical office anticipated was this: wage and hour investigations almost never stay narrow. When investigators arrive, they don't examine one employee's records in isolation. They pull payroll data on the entire staff. They review timekeeping policies. They look for patterns. And in a small, understaffed office where after-hours texts had been normalized for over a year, the pattern they found was impossible to ignore. 3 other employees had experienced similar timecard edits. 2 of them had been fielding after-hours texts even longer than Sarah. The investigation expanded from one employee's missing 35 minutes into a systemic audit of the practice's compensation records going back 2 full years, the FLSA standard statute of limitations. But investigators were already building a case for willful violation. Willful extends that window to 3 years, and it doubles the damages. The manager was interviewed, then the office administrator, then the practice owner, who by all accounts had no idea any of this was happening. That ignorance provided exactly 0 legal protection. Under wage law, employers are responsible for the compensation practices of their managers. "I didn't know" is almost never a valid defense. The owner's reaction, reportedly, was genuine shock, followed immediately by an emergency call to an employment attorney. Investigators calculated total back wages owed across all 4 affected employees, edited overtime, inflated lunch breaks, and 12 months of compensable after-hours communications. The number came to $47,200. Now, under the FLSA, a willful violation triggers liquidated damages, which is a dollar-for-dollar match of the back wages owed on top of repayment. The medical office was now facing potential total liability of approximately $94,000. What would you do if you were that practice owner? The Wage and Hour Division issued its formal findings. The timecard edits, willful violations, the after-hours text communications, compensable work time, and the manager's retaliatory comments, "We can be strict about everything, including rounding issues," cited directly in the investigative report as evidence of intent. That single conversation, spoken in a hallway, had just become exhibit in a federal wage investigation. Rather than contest the findings in a formal administrative hearing, the practice negotiated a settlement. Total back wages paid, $47,200, distributed across all 4 employees. Liquidated damages settled at approximately $31,000 after negotiation. The manager was terminated. The practice owner committed personally to a compliance audit, new tamper-evident timekeeping software, and mandatory wage law training for all supervisory staff going forward. Sarah received approximately $12,400 for time she had already worked and simply never been paid. Let that land for a moment. Not from a lawsuit, not from years of litigation. From a government investigation triggered by one person who took screenshots, logged her hours, and asked the right question at the right time. Documentation is not a formality. In wage cases, documentation is the whole game. In the months that followed, the medical office underwent significant restructuring. A written policy was issued prohibiting after-hours work communications without prior written authorization and a signed compensation agreement. New timekeeping software logs every entry with a tamper-evident audit trail and requires a manager to document justification for any correction. 2 of the 4 employees who received back wages remained with the practice. Sarah left on her own terms and landed at a larger healthcare system with a formal HR department and a union contract. Here is the broader picture, and it is a number that should stop you cold. According to the Economic Policy Institute, wage theft costs American workers more than $50 billion annually, more than all property crimes in this country combined. Most of it goes unreported, because workers are afraid of exactly what Sarah was afraid of: doing the wrong thing too early, rocking the boat, losing a job they cannot afford to lose. That fear is real, and employers count on it. What this case proves is that the first move costs you nothing. You do not need a lawyer to file a complaint with the Department of Labor. The investigation happens at no cost to you. Once an investigation opens, the burden of proof shifts. Employers must demonstrate their payroll records are accurate. If violations are confirmed, the government collects the back wages on your behalf. Sarah didn't need to go to war. She needed to go to .gov and start writing things down. If any part of this story resonated with you, the description below has 2 things: a direct link to the Department of Labor's wage and hour complaint portal, and a documentation checklist built from cases exactly like Sarah's. What to record, when to record it, and what format investigators actually need to see. And if you want to see where wage cases get even more complex, our next video covers a Texas restaurant manager who falsified payroll records for 19 employees across 3 years, and the single whistleblower who brought the whole operation down. Subscribe so you don't miss it. And if you know someone who needs to hear this story, share it. That's how the next Sarah gets ahead of it.